Case number 2355496, people of the state of Michigan versus Justin Daniel Ringler, who is defendant number 1, and Israel Alondris Clary, who is defendant number 2. Both defendants are charged with counts 1 and 2, robbery armed. Defendant 2 is charged with counts 3 and 4, weapons starting firearms. And today's an exec for a preliminary examination that was held in part. Appearances.
Good afternoon, Your Honor. Daniela Perch on behalf of People 285-495.
Good afternoon, Your Honor. David Cripps, appearing on defendant number 1, Justin Daniel Ringler. Could you tell the judge your name, please?
Justin Daniel Ringler.
Good afternoon, Your Honor. Neighborhood Defender Service by Jonathan Cohen, P86151, appearing in person with Mr. Israel Clary, who's also present out of custody and in person. Can you state your name, Judge, please? Israel Clary.
Okay, any preliminary matters before the next?
Your Honor, the people would like to just note that we did indicate that the OIC would testify to the confession of defendant 1 in this matter and play the video of the confession today. Unfortunately, because it was adjourned from the original day, communication got crossed and he was not able to make it today, so people will not be able to testify today.
I didn't expect that.
Pardon me, Your Honor?
I didn't expect that.
Neither did I, but it was unfortunately, because we hadn't initially thought we could set it. I did send out a text indicating that it was being adjourned and likely, and that is my fault, my wording, I said likely would be set for today once defense counsel had conferred with each other and we had come to the conclusion. And unfortunately, our continued text got lost in translation and he was not able to hear.
Who's the officer in charge?
Barmore?
Barbara, Richard Barber. Okay, so what is your request?
Well,
You know what, Your Honor, normally I would request an adjournment, but I believe for probable cause standards that we can continue at this point and not have to delay the court any further.
Officer Abrams is here. I'm prepared to call her.
So you were okay, people are arrested. So, Mr. Cripps, for your first witness? And I'll just announce, if there's anyone on YouTube who may testify in this case, now is your time to log off. For the record, there's no one else in the courtroom other than staff and the defendants and attorneys. Wait, I'm just gonna get your name out for you.
ABRAMS. First name TORIELLE.
Okay. Swear to tell the truth, the whole truth, and nothing but the truth. I do. Okay. Have a seat right here. It's in the front door. And make sure you speak at the mic. Whenever you're ready.
Thank you, Your Honor. Good afternoon, ma'am.
Good afternoon.
Could you tell us your name, please?
Officer Toriel Abram,
And where are you employed?
Detroit Police Department.
Back on the date of January 30th, 2023, were you also employed at the Detroit Police Department?
Yes.
And on that day, on January 30th, 2023, were you called to go to the location of 15441 Plymouth Road, City, Detroit?
Yes.
And what was at that location?
At that location was a club celebrity
Was it a Sunoco gas station?
down the street from where we were originally called. Yes.
I'm sorry. Witness put that in.
Could you put that mic? The mic
Put it on your lap.
so that myself, yeah, you can actually put it on your back.
What I was asking you is, did you go to 15441 Plymouth Road in the city of Detroit?
Yes,
And when, in that location is a Sunoco gas station, is that correct?
yes,
And at that location, did you, come into contact with a person by the name of Austin Giacomontonio?
yes,
All right. And this is in regard to, investigation of criminal offense, is that correct?
yes,
And, when you came to that location, did you talk to Mr. Giacomontonio?
yes,
Did he tell you that he, went to pick up a guy who was on
Objection, Your Honor, leading.
Gotta lay a foundation as to the conversation.
He's saying on leading, as far as repeating what he said about the foundation first.
All right, I'll rephrase it. Did you talk to the driver of the vehicle?
Yes,
Did he tell you, what had happened to him?
yes.
What did he tell you?
He stated he had been robbed within the intersection.
Objection, Your Honor, hearsay. The person he spoke to is not actually defendant.
You can't have it both ways, because I'm trying to lead her into the areas of impeachment. So she objected as to my leading question, so I can direct her into the area of impeachment. Now she's objecting because a narrative from the office. So I suggest you allow me to lead her into the areas of impeachment.
Was your objection for narrative?
No, Your Honor.
Impeachment is an broad exception.
It is for impeachment purposes.
I understand, Your Honor. I would like to note though, since for impeachment purposes, we may, depending on what the officer says, hopefully we don't need to after play video, but we may have to call back the original.
I understand that, and I hope we don't.
These are that.
Okay.
All right. Did Mr. Giacomontino tell you that he went to pick up a guy he knows by the name of Justin Ringland
Yes,
and who was with an unknown person?
yes,
Did the complainant tell you that Mr. Ringland wanted
Your
him
Honor,
to give him a
again,
right to Terry?
objection. I thought we just stated that he can do the hearsay, but he is leaving again.
This is impeaching the complaint.
Yes, but he's leading his witness.
I can ask a question to impeach the witness.
if it's for,
Essentially, cross-examination is.
it's for purely impeachment purposes and not for, this is not for the truth or truth of the matter asserted, right? Or is this?
No, it impeaches us with credibility.
Okay, well then you can speak aloud.
Did he say, did the complainant say that Mr. Ringler wanted him to give him a ride to 11741 Terrace Street?
Yes,
And did he say that he gave the two males a ride to that location?
yes,
Did the complainant then say that when they got to the intersection of Terrace Street and Plymouth Road, that one of the unknown person asked the complainant to stop the vehicle because he dropped his phone outside the car?
yes,
Did he say that the unknown person began to scan the ground to attempt to locate the phone?
yes,
That he claimed fell outside the car?
yes,
All right. Did he say eventually that the driver's side rear passenger door was open by the unknown person where Mr. Ringler was sitting?
yes,
And did he say that Mr. Ringler scooted over to the middle seat?
yes,
Did he say that's when the unknown person produced a black handgun?
yes.
When a demand was made by the unknown person to give him everything the complainant has, did the complainant say he doesn't have it?
Yes,
Did he then say that both the unknown person, Mr. Ringler, left on foot in an unknown location?
yes,
Now, while you were speaking with the complainants at the gas station, did Mr. Jacko Antonio begin to look in the backseat of his Dodge Dart vehicle?
Yes,
And when he looked in the backseat, did he find his Adderall, 30 milligrams, was missing?
yes,
So he told you that's when he first discovered it was missing, is that correct?
yes,
And then he said, well, the males must have taken it, but I don't know for sure.
correct, yes,
That was his word, is that right?
yes,
And then the complainant then produced a label for the Adderall, is that right?
yes,
Did you take that in?
no,
Nothing further.
Okay, I'll give you both. You want to stop mid questioning, Your Honor? I'm sorry.
interrupted my through.
Officer Abrams?
Yeah.
Just wanted to clarify.
My computer device.
Thank you.
Thank you.
Officer Abrams, you just testified that the victim on this case indicated to you that he picked up both defendants to give them a ride. Is that
Yeah.
correct?
Yes,
Where did he pick them up from?
I do not recall.
You don't recall. But you recall where he dropped them off?
Yes,
Where did he drop them off?
at the intersection of Terry and Plymouth.
And so while you spoke to the defendant, he actually said that he gave them a ride? Is that what?
That would be the complaint with.
I'm sorry? Or not the defendant, thank you for correcting me, Your Honor.
Yeah.
Thank you, sorry. So when you spoke with the complaining witness, he indicated that he gave the two males a ride. Did he indicate why he gave them a ride?
No,
Okay. Would you be surprised if your body worn camera does not corroborate that he indicated that to you?
yes,
Your Honor, people would like to play Officer Abrams' body worn camera. I believe defense counsel did mention it before when the complaining witness was on there about the video, so I'm assuming, I don't know if they've watched it.
I've never said anything about the body cam during this case.
Actually, it was, you said to the complaining witness that you would play it for him, and that's when I objected that he can't actually.
What's
Lay
the,
the
what- I
foundation.
don't understand what the purpose is of playing the body cam.
The purpose of playing the body worn camera is because everything that was testified to today from Officer Abrams is based on a summary of her report, but I believe the best evidence is the actual video of her speaking with the complaining witness, where we can actually hear what she asked and what the witness stated.
Are you intending to impeach Officer Abrams and
Yes,
impeachment?
yes. Very much so.
Well,
Unfortunately, but and at the same time, I believe that her body worn camera, I know officers all the time, you know, they write a summary, I don't remember every detail. But I believe that the body worn camera, you have an opportunity to ask her some questions in regards to what was said. Find out exactly who, if anyone, was picked up.
You laid the foundation when this was taken, with who?
I'm sorry,
We laid the foundation for the body worn camera.
Officer Abrams, were you wearing a body worn camera on that day?
Yes.
Was it active and operating?
Yeah.
Did you have the body worn camera on when you actually, got to the scene prior to speaking with the complaint witness?
Yeah.
Did it stay on the entire time that you were with the complaint witness?
Yeah.
Do you know if there was any issues, with your body worn camera as far as recordings or anything of that nature on that day?
No.
If I play your body worn camera, would you be able to verify that it's your body worn camera, after the first probably few seconds?
Yeah.
I can pause it at any time.
Yeah.
Your Honor, may I play what is going to be People's Proposed Exhibit 2? Yes.
Judge, before she does that, can I ask some further board here?
About the camera? I mean, the video?
Yeah.
Yeah.
I can wait. Thank you. Is it officer, is it possible that during these, when you're at the scene, at this scene, that some of the conversation that you may have had may not be on body cam? For example, like the 10-minute interview may end before you may continue talking with the complainant after the body cam.
Your Honor, leading the ordinance, he's already asked her the question.
I guess you could ask it on cross or redirect.
Okay.
Did she want to answer? I'd like to know.
I'll
She
wait.
seemed like she was going to answer.
Well, I guess if you want to withdraw or you want to say?
I'll withdraw and save it.
Okay, you could ask it.
No, I just want to stop right there.
Just pause right here.
Okay. Thank you. Not even. Hit mute.
I just turned it on.
Thank you. So, yes. Thank you. Before we continue with this, this video, obviously, it is not a clear video. Do you agree?
Yeah.
Is this something that happens with your body worn camera, or do you know what the issue is here?
No.
Okay. Have you reviewed your body worn camera since today?
Yeah.
Okay.
Recognize this as the body worn camera of yours on the day that you took
The, from the complete
witness?
Yeah.
I
I
know
it's very grainy. I've watched it a few times, so I can recognize, but
Could you describe where this is from?
at?
Yes, it is at the Sunoco gas station on the intersection of Clemens and Greenfield Road.
And
And, at the beginning of the video, was that you exiting the scout car?
Yeah.
And where are you right about this point in the video?
In the parking lot of the gas station.
okay.
Are you playing? Let me turn the volume. You know also who played what second you started?
Yes, Your Honor. Sorry. Just that went hidden on me for a moment there. Okay. Right, people are going to continue with Officer Abrams' body worn camera video on the video at 33 seconds. And pause for a moment, make sure that the sound is back on, Your Honor. I'm going to pause right there for a moment.
You share the screen, did you hit the little box in the lower left corner? If you unshare and then reshare, there's a box in the lower left corner that says share audio, it'll bring your audio through your
Okay.
computer so that it'll actually go through the course.
Okay. Thank you. Thank you. Just to confirm, Your Honor, were you able to hear the audio up to that point? Okay. So I am going to rewind it back 30,
Echo, so
33, and I am going to
Trying to get the sound so that you all can hear the sound.
No, you didn't. Okay. You gotta go back to the page. Yeah, yeah. Yeah, you know. Go share. No, this is just the green button. Go share. That's the magic one.
Okay, thank you for cutting our time a little bit there. Your Honor, my apologies. Hopefully you can hear it now. I have taken the video back to 32 seconds on the video.
Is he the old clock? He the old. Oh.
I said, okay. And
can you hear it? So can you play it for Officer Abrams?
Yes.
TV, and then if your clients need to hear it, play it again.
I'd like to hear it too.
I can't hear anything.
I think both councils, and I would like to hear it also.
Yes. If you all don't mind. Why is so?
So, yeah, all the share is correct.
Here's my question. Is the only thing you're sharing audio, there's nothing visually to see for this? Ms. Parrish?
I am going to make sure that I actually,
Ms. Parrish, is there anything on the video that we can see?
sorry, how did I stop sharing? Sorry. Leave the meeting to see if we can start it over. Sorry. Make difference? And what were you saying?
Is there anything visually that you're trying to show?
No, actually,
It's
just
just
all the
audio.
words, yeah,
Okay,
because
so we
the
don't-
video is grainy anyways.
We don't need to put on screen.
Right. Do you want to come up here to?
I was gonna offer to play it online for the clients at the same time, but
If that's.
I don't know if that's helpful. Okay, that's fine. Okay, go ahead. Fine.
For the record, Your Honor, we're starting back to that same spot, this time at 32 seconds as opposed to 33. I'm going to stop here for a moment, officer, at 1 minute and 6 seconds. If you could please identify who is actually speaking on this video.
Mr. G. Antonio,
Is he speaking to you or to a different officer at this time?
the different officer.
Okay, so you're walking up mid-story, correct?
Yes.
And in this story, have you heard anything yet about giving anyone a ride or anything like that yet? No. Okay. Your Honor, I'd like to continue
At what second?
at 1 minute and 6 seconds.
Oh, yeah, I was friends, I worked with the kid, I used to paint.
I'm going to stop here at 1 minute and 52 seconds because I know we can't see the video really well, but we hear now multiple voices. So aside from the complaining witness speaking that you just identified, who's the female voice that's speaking in this video?
The passenger of the vehicle.
Okay, and who is she describing?
That would be speculation at this. Who's somebody else?
Your Honor, she took the report. She's the one indicating what the complaining witness and the report she took. They're all laughing. Everybody's speaking to this. I think the totality of everything that the officer heard that day is what went into her report.
I'll object as to what the passenger said on hearsay grounds as well.
I was gonna say hearsay, also relevance, what is it? I know I'm not objecting, what's the relevance of first aid?
Nothing, I'm just trying so that I can lay the foundation of who all is there, Your Honor. It's not so much what she's saying, I'm just trying to figure out who is saying what, because we don't have, as you can tell, the video is not that great, so I'd like to identify who's actually speaking.
woman, male.
Okay.
So
So
how would she know? She didn't see the robbery, she didn't see who was sitting where.
Who are we saying she?
Officer
The
April,
witness on the witness.
right, that would be hearsay for her, for Officer Abrams to say who was doing what. Based
So
off
she
of
took
like
the
a
report.
witness.
She can identify each of the persons, not for the truth of the matter asserted, but just basically so that we ID who she came in contact with that day.
Officer Abrams was saying who was talking.
That's all I'm asking
Okay,
for.
but not about the contents of what she said happened. She would testify, we're not impeaching her, she, you know.
Exactly, and that's all I wanted to
Okay.
just identify who the parties are in the video. Who was the female voice that was speaking?
The passenger of the vehicle.
Again, it's speculation for part, she was never a passenger.
That is, so the response is the issue. Speculative to say that she was a passenger because Officer Abrams was not there to see whether she was in the passenger.
Well, if
Do you know the person's name that you were?
No, I do not.
Your Honor, may I ask this? Did you actually observe this person in a vehicle?
Yes,
In which vehicle did you observe this person?
the gray Dodge Dart.
Okay. Did you actually observe her as a passenger in that vehicle?
Yes,
Your Honor, at this point, she did see her in the vehicle. She's saying she's a passenger in that vehicle. At the time she arrived at the gas station.
Correct.
That's fine. That is not necessarily at the time of the incident.
Thank you. And Your Honor, we're continuing the video at 1 minute 52 seconds.
It's with J-Rock. All right, and G-L-E. It's like. You said G-L-E-R? This is the number he gave me. 313-314-45.
Very supposed to, all right, this week the name was.
Get it going. Please raise the mic.
Yeah, but I don't want to just end up with a shootout. Which guy? Black guy was short.
Black out, like, really short.
Okay, but how much you think?
So disregarding what the female voice is saying, I stopped at 3 minutes and 15 seconds, Your Honor. Disregarding what the female voice is saying, are you obtaining a description of both suspects at this time?
no,
Okay. Who are you getting a description of?
the unknown male.
No, I'm sorry. I'm saying, let me rephrase that. From the gentleman who's speaking that you identified as the complaining witness, who is he describing to you right now?
Mr. Justin Ringler.
Okay. And did he show you a picture in this?
Yes,
Okay. After that, he starts, do you recall what the picture looked like that he showed you?
no, no,
We just heard him indicate something about a black male. Who is he describing there?
the unknown male that was occupying the vehicle.
Okay.
Like a bunch of weird. Like a rag doll.
No, but of course we were in the back, or we were all, we weren't. All we were. Oh, no, Jeff, that's not great, yeah, somebody, and, and I think like black people, like they had all black. Said black man, I think he was nervous, honestly. Oh, he had a gun, he had that, he went, and then. What did that? What did the gun look like?
Just like.
The black man. I know that guy, like, but I don't know. They said it was another, it was a black guy.
I'm gonna pause there. So I hear your voice
saying, so it was the black guy, are you asking on who, because they were just talking about a gun? Did you confirm which defendant was holding the gun?
Yeah,
Which one?
the unknown black male.
Okay. We stopped at 3 minutes, 55 seconds, Your Honor. Continuing the video at 3 minutes and 55 seconds.
He said he lost his phone or dropped his phone, so he's around, and then he went to go get in the car, and left it, and went,
I'm gonna pause there. Not
I-
that we can
This is all
discuss
your- This
anything.
is all hearsay.
Okay, and I'm just saying, not that we can discuss anything she said, but up to this point, have you heard the defendant indicate anything of what you discussed in regards to them driving around? Or anything of that
I
nature?
believe she started it after that point, where there was a discussion with driving around.
I didn't start after, I started when she got out of her vehicle. And then at 33 seconds, when she walked up and he was talking to somebody else.
I heard it differently.
I can rewind it, but, you know, to verify, but at this point, there's nothing been in this video that has indicated anything about driving around. He did indicate that he went to pick them up, but again, not actually driving them around or dropping them off. That has not been said thus far in this video.
Let me get it different.
Where would you like me to start?
Very good.
Your Honor, the people are going back to the very beginning. Starting to play, yeah. Pause it. It's been playing now for 12 seconds. It started at 0, it's been playing for 12 seconds. Officer, could you please describe what, I know it's hard to tell, but where are you at right now in the 12 seconds?
And the passenger side of the scout car.
So have you made contact yet? Have you made contact yet with anybody?
No,
All right, so we are, I just want to confirm that we are at the beginning. So I'm going to stop again where I had stopped originally at 33 seconds when you described where we were at. So to confirm, at 33 seconds, where are you on this video?
in the parking lot of the gas station.
And isn't it correct, you have yet to make contact with anybody involved in this incident, right?
Yes.
Thank you. To continue, Your Honor, at 33 seconds. I stop here, just to make sure that everybody here, the gentleman who just indicated, that you referring, I'm assuming, was he referring to you saying, stop, she's gonna take the report?
Yeah.
Okay, was that an officer who said that?
Yes.
At this point, again, we haven't heard anything about someone driving anyone or dropping anyone off, correct, officer?
Yes.
Karen, can we go, do you want me to just continue with this where it was at, just to, so that
So
defense hears that
I
it
would like
hasn't
to
been
hear
said?
the entirety of
You
the
got it.
video. You started at 3 minutes and 55 seconds.
Yeah, do you want me to just keep playing at this point?
That's up to Mr. President and Attorney. They don't hear it before you stop.
That's okay, we're at 1 minute and 12 seconds.
I find you can stop at any time. I've already made my record.
Well, I would need to start at 3:55.
You want, okay, that's what I was asking, I thought you said you wanted to play it all the way through, I'll go back to
If they,
3:55. Do you want to hear it again to verify that it has not been said?
No, I'm not saying it's not a body, but it may have been said before the body started.
And if it was, it wasn't said to her, but okay.
I believe the integrity of this office.
And it's up to you if you want
Your Honor, I'm sorry, you said we stopped at 3:55.
That's what I have last time.
What you got?
Do you know why it's really?
No, I do not.
Like kind of short.
Like I'm waiting for this. You know, I'm gonna rag off.
Oh, you know what? That's really what I was getting to. The rest of it is the female speaking on the video, because that's not.
Yeah, and honestly, none of that, I'm not even gonna ask her questions about as to what was said with her. I'm just trying to get it to the point of the questions that they asked about the driving around, and these are the questions that were towards the impeachment.
Thank you.
What is it?
Your Honor, I'm at 3 minutes and 53 seconds, 2 seconds before where you said we stopped, and I'm gonna resume the video.
He said he lost his phone, or dropped his phone, so he's around and around, and then he went to go get in the car. And went, and then he like, he went looking for his phone again, and then he was like, and he's like, give me all your shit, blah, blah, blah. And what's that?
Your Honor, just to note, I have not paused it, so I want to concentrate on what the complaining witness is talking about right here. Is he still describing one of the, suspects?
Yeah.
Okay. What is he describing? Do you recall?
The unknown man.
When you say unknown, the unknown African American?
Yeah.
Oh, so that's for just. A black guy sprayed that in his face. And so Justin had the gray hoodie on and right hand. I'm the younger.
Nope, I don't know anybody.
We'll start taking, I'm sorry. We'll take it, wait. Like, oh, what did you run off?
I need my phone on the side, I got my wallet. I had it right here.
Right.
Anybody ever get it?
Yeah. Get a file for everything, right, just report number, okay? Yeah.
So I'm pausing it there. Oh, well, that actually was the end. At the very end, you indicate that, you get in the car and you're gonna bring them the report number.
Yes.
When you say the report number, is that the police report number from the information you obtained from them?
Yes.
So you were gonna go back to your, how does that work? You go back to your vehicle?
Yes, write the report number on a report sheet and just hand it to the victim. At that point, the victim, he came up to our police car and my partner handed it to him out of the driver's side window.
Okay. So, Your Honor, I believe I have a few more questions, but I think we're good with video. But I do have a couple of questions in regards to the video. But officer, in regards to, you said you gave them the police report number. After you gave them the police report number, the report that defense was asking you on direct, asking you questions.
Is this generated immediately, or do you go back to your precinct and then make your report at the end of your shift, or how does that work?
It can be done either way. However, I do my reports right away. I get them started in the car.
Now, when you make these reports, are you quoting people verbatim, or are you making a summary of all the information you obtained?
For the most part, a summary of the information. I don't go verbatim.
So I know that a lot of people, and we disregarded the female voice because of hearsay, but I know a lot of people, not only complaining witnesses, but also officers were talking in that video. So did you obtain information for your report, not just from the complaining witness, but the other people that were on the scene, including officers?
I don't recall.
And the reason why I ask is because in the beginning of the video, it appears that you are actually coming up when the complaining witness is mid-story or mid-incident, correct?
Yeah.
Do you not agree that nowhere in this video does the complaining witness or anyone else at any time in this entire video, does it say that he actually gave 2 males a ride?
I believe the portion of the video that was not showing is the part where he said it, because I didn't ask him in the beginning. It was asked later on down the line after getting a description of these males.
Officer, though, when I asked you initially, you indicated that everything is on your video. Is that not correct?
Yes, and I also stated that I was not aware of the malfunction of the body camera. That's more of a department issue.
So let me ask you a question. So, did watching this video refresh your memory of what occurred?
Yes.
So is it not fair to say that it's possible that whatever was actually, if there was additional information, that you can't be certain exactly what was said?
Yes.
So it is possible that he could have said he was intending on giving somebody a ride, as opposed to. It's okay. As opposed to he gave somebody a ride. Is it possible that that could have been said?
Yeah.
Objection calls for speculation with respect.
Your Honor, we're in the middle of trying to figure out how this came to be, and you know, and this is very serious because we're calling into speculation, or excuse me, into question the validity and the honesty of the complaining witness. I'm not saying, sorry?
And accuracy.
And I'm not saying that the officer, I deal with officers every day, I'm not saying that the officer is intentionally giving any information, but the, you know, incorrect information, but I think it's imperative that we go into this a little further because we don't have the best evidence. We don't have the video that supposedly he may have said something more.
Officer Abel did say more.
Right, but she has also just said that it's possible he could have said it differently than how she wrote it.
Mr. Cripps, you had an objection?
Well, I think she explained it in terms of equipment function going on here. In terms of not capturing all the, I don't want to put words in the book, but I thought I heard her say it's not capturing all the conversations that were going on.
And because of that, I think it's fair for me to ask her, is it possible in that other conversation? I trust her, I believe that there may have been additional, but at the same time, she also is indicating that it may have been said differently. So I think that it'd be only right for us to explore that a little bit more.
I'm sure it's possible, and it's leaving to worse things. I'm gonna allow it, but, I think she narrowed it down to what she heard and who she knows or not.
As far as your actual report, Austin,
Yes.
do you quote anybody in this report?
I don't recall.
Okay, if I showed you the report.
Exhibit 2, correct? Or
Yes,
is
Your
that-
Honor. Suppose exhibit, or B,
B, sorry.
exhibit B.
It's already been admitted as exhibit B for.
Your Honor, may I show her report? I did hold it because I had written something, so I don't think it's important, but still, I don't want to affect it.
Well, that's why I said we have exhibit B if you want to show her what's already been admitted to evidence. you want a copy without her hearing?
I think the original B was taken from the officer of charge.
Okay, all right.
Sorry, Your Honor, yeah. I looked at his and his was even marked up more than mine. Officer, if you wouldn't mind, thoroughly just reviewing your report. I don't need you to read from it, but once it's refreshed your memory, I will restate the question for you.
Yes.
Thank you, officer. So in your report, do you actually quote anyone?
Not verbatim, no.
Okay. Do you quote, and I say anyone, specifically the complaining witness?
Not verbatim, no.
So would it be accurate that you're summarizing the information that you attempted to obtain?
Yeah.
So in the report, you indicate initially you indicate Mr. Ringler wanted Mr. Giacomo Antonio to give them a ride. And then say, you continue and then say, so that part that you wanted him to give a ride, but then you continue and say, Mr. Giacomo Antonio, who was with Ms. Jordan in the passenger seat of the Dodge, gave the two males a ride. Now, again, do you remember verbatim that the complaining witness actually sent those words to you?
I recall him telling me he picked them up from a location to give them a ride to the address on Terry. However, that video.
So if I can stop you there, so he said that he picked them up,
Yeah, okay.
but did he actually say that he gave them a ride?
He stated that he gave the address to Terry, so I'm pretty sure he didn't pick them up at the intersection of Plymouth and Terry to drive them to a house on Terry.
So, when you say he picked them up, so did he give you the location of 11741 Terry Street is where he picked them up?
No, he stated that's where he was taking them to drop them off.
So, but you don't recall where he supposedly picked them up?
No, I remember him showing me the address on his phone, but like I said, the video, the body camera didn't show that part.
So it is possible that you misunderstood and that actually this incident occurred at 11741 Terry Street where he picked them up.
Object to the form of that question, she just explained that there was an original address, it didn't show, it was on his phone, she didn't remember it. And then she said he stated that he gave him a ride to that location.
She said that that's what she assumed. She said that he said that he picked them up. And then she went on to, in her report, to speak about Jordan Cervantes, the woman that we've already indicated that her testimony is not to be heard. And she continues on that, saying that in the passenger of the Dodge gave the two males a ride. It does not say at that point that he actually said that to her. It's possible that the other witness may have said that. I do not know. But in this actual report of hers, she's not quoting Mr. Giacomo Antonio, or anyone else at this time. Is that correct?
Yes.
Attorney Cripps, redirect. Clear that one up.
You're at a point, I only have a couple more questions. I want to beat a dead horse here. Officer Abrams, aside from, I know I started touching base, is this the only report you made of that day?
Yeah.
Did you take an actual statement at any time of any of the people involved?
No.
Was this particular report reviewed by any of the complaining witnesses for validity or signed?
No.
And just to be clear, are you aware if any statement was given?
No.
after this day, after you took that report, did you investigate any further on this matter?
No,
Okay. So your sole duty in this entire investigation was just taking that report, correct?
yes,
So you didn't have any follow-up later or any interaction with the actual suspects?
No.
Okay, did you go to see the location that they described to you?
yes,
Okay, and, do you know the crossroads of that location?
Perry and Plymouth.
Pardon me?
No, the intersection of Perry and Plymouth.
Okay, that's where the incident occurred?
That's where they stay. That's where we originally were dispatched to, yes.
Okay. So, Terry and Plymouth, but where did you take the report?
At the Sunoco on Greenfield.
Okay. So you went to Terry and Plymouth?
Yes,
And Terry and Plymouth, isn't that just a couple houses down from the actual, location of where this occurred at 11741 Terry Street?
yes.
So are you trying to tell us that he gave him a ride just a couple houses down?
Where he came from, right from.
Well, you indicated earlier that he gave him, that you started from Plymouth and Terry Street.
Yeah, that's where he stated the incident took place at. However, he said he gave me the address of where he was taking the gentleman to.
But, again, so you're not sure if the pickup spot was Plymouth Road in Terry, or if the pickup spot was 11741 Terry Street, or if the pickup spot was anywhere else.
The address he showed me in his phone is not on my body cam footage.
He showed you a third address?
No, the Plymouth and Terry is where he stated. The male got out of the vehicle, scanned the ground. That's where he stated that happened. He never said he picked him up from there.
So if he were to tell you that he picked it, so you don't know if he actually said at any time that he was supposed to pick them up at 11741 Terry Street?
I don't recall. I believe that's the address he said he was taking them to. He showed me something on his phone that had an address.
But you're not sure, because we saw in there, he kept giving the address of where to go, and you said that you followed up at Plymouth Road and Terry Street.
Correct.
So isn't it fair to say if you followed up on Plymouth Road and Terry Street, that that's where you went to go investigate? That's the address that he gave you?
No, that's not where we went to investigate. That's where dispatch originally dispatched us to.
So you never actually went afterwards to investigate the location of this incident?
It's an intersection. It's just a road.
So you never went to 11741 Terry Street?
No,
So you never followed up at all as to the locations, anything after this?
no,
And it's not your job to do that, was it?
no.
You had other officers to do that, correct?
We didn't need officers. That's more of a detective type of job.
Okay. To investigate that.
Further, yeah.
Okay. So if your report is different than, let's say, another officer's or the OIC, would you say that they're wrong?
Objection for that question.
I'm just trying to find out, because everything is that right now, the impeachment of the complaining witness is standing on one officer's report, and this officer didn't even go to the place afterwards or investigate. So I think it's only fair that I can ask her additional questions as far as this particular report. Is her report accurate? Would you say that if the OIC's report is different than yours, would you say that your report is accurate?
I only can report what was told to me by the victim.
Okay, but you just said that your report is a culmination, not a quote of the victim, correct?
There's no quotation marks in that report.
So it's not exactly what the victim told you, it is a summary of the incident of all the information you obtained at that gas station.
It's what the victim told me. It's just not each and every word that came out of their mouth.
But did you hear at any time that he told you what you wrote in here in the actual video?
No, because the video.
Okay, yes or
I
no?
think it's unfair to cut a witness off when there's an
I'm
incident.
asking yes or no, Your Honor.
She said no.
Well, she might not like the answer she gets, but she's trying to explain to the prosecutor.
I didn't ask for an explanation, I just said yes or no, if she actually heard what was written in here in the video.
I don't think it's fair to cut a witness off sign up.
Let me answer my question. Representative, and we don't do it.
Officer Abrams, finally, do you recall what you were investigating that day or why you wrote this report? What type of incident it was?
Yes,
What kind of incident was it?
an armed robbery.
Do you recall, while taking this information, if the complaining witness indicated that a weapon was used?
Yes,
Did he indicate who used the weapon?
yes,
Do you recall who it was?
yes, the unknown black male who occupied the vehicle
And do you recall whereabouts that incident occurred?
within the intersection of Terry and Fleming.
So there's no question as far as why you were there, who had done what, and where it happened, correct?
I'm sorry, can you
Object
repeat?
to the form of that question, Your Honor.
So all of the information you just gave before, and I will rephrase, Your Honor.
In the last 2-3 questions,
Yes, all of the information that, the last 2 questions you just indicated. Are you confident that you obtained correct information?
From the victim, yes.
Okay. And,
I'll object to strike based on speculation as to whether it's correct or not.
now you're calling her speculation, but they called her in to, as an officer, taking this report, saying that she wrote the report. And I think what's important is the facts of the actual.
I understand your objection. What, can you rephrase the question as whether or not what she wrote in her report is accurate to the best of her ability as far as what she heard? Because
Okay.
whether it's correct as to what happened, once again, she wasn't there.
So I don't want to have to repeat those questions again, Your Honor. But in your report, did you indicate what the incident or the alleged crime was that occurred?
From what was told to me, yes.
Did you, and what was that crime again, please?
An armed robbery.
Okay. And did you correctly report who supposedly did this crime based on your initial report investigation?
Can you repeat that?
Did you correctly report, whether it's a description or the actual people's names in your report, who the suspects were that supposedly did this crime?
Objection, Your Honor. She can only testify as to what was told to her.
Right, I'm asking, did you correctly put it in here, in your report?
Yes.
Okay. How many people were involved?
Objection, Your Honor. She can't testify to any of that. She can only testify what she was told.
How many, yeah, so
How many
were you
people
told?
were you told was involved?
2.
Did you put that in your report?
Yes.
Did you put in your report, the descriptions that, you were possibly given?
I don't recall.
Okay. Did you hear the descriptions on the video that we played?
Yes.
So if you didn't put those descriptions in your report, it would be fair to say, though, that those descriptions were given to you, correct? Based on the video?
Yes.
So with that being said, it is possible that your report is not 100% correct in just a summary, correct?
Yes.
No further questions. Thank you, Your Honor.
Now, as I understand this here, you're doing your best you can here in terms of remembering everything that was said. Is that correct?
Yes.
And everything that there may have been things in your, you wouldn't, let me strike that, you wouldn't intentionally lie in your report.
I'm sorry, can you repeat
You
that?
would never intentionally, I assume, lie in your police report.
No.
And you drafted this police report up not too long after this conversation. Is that correct?
Yes.
And you will it, is it accurate based on what I'm hearing you say, that there may have been things said to you that were said when the body cam was in play?
Yes.
You also told the judge there was some little bit of body cam malfunction, if I heard you use that word,
Yeah,
which could have interfered with, the body cam to pick up some of the things that the complainant said. Is that
Yeah.
correct? Now, you would agree that, you prepared your own report, is that correct?
yeah,
And as you explained to the judge over and over again, the location of where the complainant was picking up the Mr. Ringler, is not in your report, is that correct?
yeah,
He showed you, the complainant showed you on his phone where he picked up, but you don't remember what location that was, is that correct?
yeah,
And you didn't put that down in your report where the pickup spot was, is that correct?
no,
So,
yeah,
all right, so it's fair to say that when we talk about this other location, you described as Plymouth and
Terry Street,
Terry,
yeah,
that's not where they were picked up, that's where it ended.
yeah,
All right, so they're, logically, from what you said, they were picked up at another location and driven to that location,
yeah,
all right? And essentially, that's what your report says, when it says that Mr. Austin Antonio, who was occupying the driver's seat, stated he went to pick up a guy he knows by the name of Jeff, right?
yeah,
So it's not your report says he stated that, is that correct?
yeah,
That means it came from his mouth,
yeah,
all right? And then your report goes on to say that, he gave the two males a ride.
yeah,
So that logically means he gave them a ride from the unknown pickup location to where this is
Objection.
concerned, is that right?
Your Honor, and
Is that what you were told?
yeah,
he's leading the witness and this is his witness and saying this is what it meant. I know he's used to being a defense attorney, but he's leading her and he's not, this is his witness.
This is rehabilitation of this witness, that's what the report shows.
And that is not verbatim what the report says. I had already read the report verbatim to her earlier.
I think she's misleading here because the officer is trying to explain the pickup spot where he picked up Mr. Ringler.
He doesn't know the pickup
It's
spot.
an
She doesn't
unknown
know the
location.
pickup spot.
Right. And naturally, where the location where this occurred is where they were driven to. So I'm just establishing, it's rehabilitating the part of the statement that said that she gave, and he said he gave the two males a ride.
It is verbatim from the statement?
Yes. Mr. Giamatti, who was with Miss Jordan Shavante in the passenger seat of the Dodge, gave the two males a ride. That's what it says.
I'll allow it. I need a copy of it. This isn't a good-
Yes.
I don't, if you need one for.
I underlined it.
It is.
All right, there's no word.
There are no notes on there, are there?
No.
Okay.
Thank you, sir. All right. I think I left off where it says that, your report says that the complainant said he gave the two males a ride,
yeah,
and that's in your report.
Yeah.
And that was sent to you by the complainant.
Yeah.
And then he said when Mr. Giacomoni said that when he got to the intersection of Cherry Street and Plymouth, that's when a person spoke up to say, stop the vehicle.
yeah,
That's in your report.
yeah,
And that's what you were told.
yeah,
And when you got that location, somebody told him to stop the vehicle.
Yeah.
And that's when the person got out and was doing whatever they were doing. Is that right?
yeah,
Now, it's clear that the complainant told you that both the persons who were in his car left on foot in an unknown location.
yeah,
That's in your report,
yeah,
and that was sent to you, is that right?
yeah,
Now, it's also in your report, when you were speaking to the complainants that the complainant, Mr. Jackson and Antonio, began to look in the back seat of the Dodge Dart, is that right?
yeah,
and found out that his Adderall was missing, is that correct?
Yeah,
Your Honor, I'm gonna say this is beyond the scope of cross, none of this came up. Or in redirect, excuse me. Because none of this was brought up in cross.
Brought it up clearly in my direct earlier.
I don't recall that.
And
Again,
this is for
again, if it
impeachment.
is, it
It doesn't matter, this is for impeachment.
it does matter, Your Honor. His, line of questioning now is based on my cross. My cross did not ask anything in regards to that I'm wrong. If he wanted to go deeper into this, he should have did it during direct.
Well, I did, I'm trying to rebut now her.
There's nothing to rebut. I didn't talk about that at all.
She's suggesting this officer's a liar.
I am
I'm
not
trying to
suggesting that.
rehabilitate this officer, but I don't think she is.
Your Honor, I have never called this officer a liar.
I know, nobody did, but because on cross, you played the video, and the question here is whether or not there was anything outside of the video that was discussed between the witness and the officer. Attorney Cripps is asking or getting into that as far as what Officer Abrams said, that there are things that were not on the video, and I believe that Attorney Cripps is getting to the point that the Adderall, which is
Yeah.
one of the main items here for the armed robbery, whether or not that was stated by the complaining witness as being taken. And the completion of the video that was not shown. That's what I'm understanding.
That's correct.
I would draw the objection.
Did you report did the complainant tell you they began to look at his back seat and discovered his Adderall was missing?
yeah,
Did he tell you that the man must have took it? He wasn't sure.
yeah,
Right. Now, you talked about some equipment malfunction,
yeah,
and sometimes the body cam stopped when you were still talking going on.
yeah,
And is it fair to say that this conversation actually occurred? Is that correct?
yeah,
You didn't make that up, is that correct?
yeah,
You did not make it up, I'm worried about that.
yeah,
All right. And so it's just fair to say that this conversation may have occurred when the body cam just didn't pick it up because it was important.
yeah.
Nothing further.
I have just a couple of, okay.
Yes.
Officer Abrams, the 6-minute video that you viewed earlier, that was not the only recording that your body camera picked up during this investigation. Is that true?
Do you mean about that incident just now?
Yeah, I'll rephrase it. Were there any other recordings from your body worn camera during this investigation with Pagidala and Giacomo?
From other officers?
No, from you.
No, no,
So there isn't, in reviewing your body worn camera, you don't recall viewing almost a 3-minute video that took place towards the end of your interaction with Mr. Giacomo?
I don't recall that.
But it's fair to say, is it fair to say that between malfunctions of your body worn camera and portions of your interaction with Mr. Giacomo Antonio that simply were not recorded, that there was quite a bit of conversation that was had between you and Mr. Giacomo Antonio that's just not recorded?
Yeah,
That's all I have. Thank you, officer.
Any cross or something that? Okay. Thank you. Any other witnesses or defense?
No, Your Honor. Or defense, I'm so sorry.
No, I'm not calling any witnesses. Thank you.
Ready to go on?
No witnesses, Your Honor. I did want to proffer as a defense exhibit. I don't know if it would be defense exhibit C, but it would be a 2-page, both front and side view mugshot of Mr. Israel Clary that I'm hoping the people would be willing to stipulate that that is an accurate photo of Mr. Clary on the date he was arrested and fingerprinted of February 7th of 2023.
Your Honor, at our initial beginning of this exam, defense did come to me, and have me show that to the OIC. The OIC believed that that was correct. I can stipulate that the OIC has indicated that that is the correct photo, Your Honor. I do not know of myself because I wasn't there, but the OIC did confirm that he believed that that is the photo that was taken.
That's up to you, you have to stipulate.
Well, as I said, I can stipulate to the OIC agreeing. I can't, I myself do not know, but I can stipulate to the OIC agreeing. Unfortunately, the OIC is not here today.
Are you stipulating the entry? So is it one exhibit or two?
It's 2 pages, Your Honor. It's just a close-up picture as well as a second page with both side views of Mr. Clary, just a few days after this incident.
Okay, so I will be labeled as the live scan summary report, and I'll have it as exhibit C.
Thank you, Your Honor. The last thing I wanted to do on behalf of Mr. Clary, if the court would permit, and not trying to really engage in theater here, but I think it is very persuasive. If the court would permit Mr. Clary to very briefly remove his mask so that the court can actually see his in-person 3-dimensional face from the front and the side, I would ask the court to take that into consideration for purposes of the identification testimony that's been offered, just to show that that's what his face looks like, because it's difficult to say. I mean, we can take certain things from 2-dimensional pictures, but I think a 3-dimensional perspective would be very illustrative in this case.
Your Honor, I'm a little confused as to how this will how this is being entered in the court, considering the person who identified the defendant number 2 is actually not here, and he was already identified, and he was identified in person as he is, and his appearance hasn't changed that much since last Thursday or last week, excuse me. So I'm not sure what the purpose is of this. Because myself and Your Honor, we can't identify him. We can both look at him, but and we know that he's the same person that was here when we first started. And we have the testimony from the plain witness who ID'd him. So I'm not sure what the purpose is.
I think the purpose is because the 6-pack.
It's both the 6-pack and the very particular descriptive testimony that the individual gave of the face of the person he claims pointed a gun at him. Now, he identified my client in court, but my client had his mask on the entire time. So the other issue, again, being that I think this particular identification that's been done, both the extremely unduly suggested photo lineup, in which that was the initial identification, and then again, the very particular description of, I think the quote was, he had a cartoon face, and I think he referred to it as a smush face.
I don't know what that is.
I don't either.
I have no idea. I actually went home trying to figure out what a cartoon face looks like because they look like everything. I completely disregarded that because it made no sense.
Your Honor, though, something I would like us not to disregard is that he also identified him in his testimony indicating that he actually found him on Facebook. And I don't believe either one of those pictures there show us what this person looks like on Facebook. So I wouldn't say that the lineup was actually his initial identification. His actual initial identification was Facebook.
I would allow you to Clary to take the mask off.
And then he turned to the side.
And for the record, Mr. Perry stood up and took his mask off and turned sideways.
Thank you, Your Honor. The defense on behalf of Mr. Clary rests at this time. Assuming, I believe we did move in, I'm moving in Exhibit C as well as I believe I introduced Exhibit A, the 6-pack photo lineup, and we rest.
Okay. Ms. Parrish?
President, people would move that defendant 1, Justin Daniel Bree,
Ringler. He bound over on count 1, robbery armed, count 2, robbery armed, and that defendant 2, Israel Alondras Clary, be bound over on count 1, robbery armed, count 2, robbery armed, count 3, weapons felony firearm, count 4, weapons felony firearm, and reserve argument. Thank you. Whoever would like to go first?
Thank you, Your Honor. Your Honor, defense on behalf of Justice Ringler is asking for dismissal of charges against him. And one of the jobs or roles of court in a preliminary examination is, of course, to judge credibility and believability. In the famous case of People versus Tremel, Tremel, Anderson, the Michigan Supreme Court in 2018 says that we hold that a magistrate's duty at a preliminary examination is to consider all the evidence presented, including the credibility of the witness's testimony, and to determine on that basis whether there is probable cause to believe the defendant committed a crime. Go on to say that during a preliminary examination, the judge has not only the right, but also the duty to pass judgment not only on the weight and accuracy and competency of the evidence, but also on the credibility of the witnesses, citing ample Michigan case law. I love this case because it originally came out of this courthouse, where Judge Miller had said in a case, in this case, the Anderson case, that she didn't believe the credibility of the complainant and she couldn't in good conscience buy the case over. That case, believe it or not, was appealed by the prosecutor's office all the way up to the Supreme Court, where we came up with this wonderful decision regarding credibility. I say that because I think that's what this case before you now presents. I don't believe anything the complainant had to say in terms of regarding what occurred that night. It's very clear that there was from reading from inferences of this case, that there was a narcotic transaction, that the complainant got beat out of money for his Adderall that he was selling. We know that because if you look at the impeachment of his story, and everything surrounding it, it just doesn't make any sense. He knows Mr. Ringler from the past, so he went to at a meat location, and the meat location was to go to drive to another location to where the drug transaction was going to occur, probably at a secluded, safe spot. And that's confirmed by what was taken down by the Officer Abrams in her report, where she says that the complainant stated that he went to pick up the guy, and then that they gave the two males a ride, and they drove to the intersection of Terrace Street and Plymouth Street. So we know that his story about that he drove to a certain location, the incident took place there, is simply not true. And then when they get to that location, something happens inside that vehicle. But however, he's not even in a position to say that the Adderall was even taken at the time of this alleged robbery, because we know, thanks to Officer Abrams, that after this occurred and when she was investigating it, he began to look at his back seat and discovered that his Adderall was missing. And he says to the officer, well, the males must have taken it, but I'm not for sure. I'm not for sure. Well, the whole essence of this case is alleged armed robbery, where at gunpoint he claims that he gave up this medication, this Adderall. But then he tells the officer right afterward that he's not even sure maybe that it was even taken. It must have been taken because he can't find it in his back seat. That certainly undercuts his credibility, which he claimed on the witness stand, supposedly, that my client reached across the seat and grabbed the prescription for the Adderall medication that was sitting the lap, someone's lap at the front seat. So Judge, I don't believe his credibility is worthy of a mind over in this case. We never heard any testimony additionally that Mr. Ringler was ever armed with a weapon. That Mr. Ringler ever utilized a weapon in any way. We've got the testimony that says that there's a second complainant who never even testified in this case, Gordon Cervantes, but that's count 2 in relation to my client. And I don't think there was any sufficient evidence that she was robbed of anything in this case. But essentially, when you weigh the story that was told by him on the witness stand with the impeachment that we had of by Officer Abrams of the complainant himself, this doesn't add up to a robbery in this case. And therefore, Your Honor, we ask that the charge be dismissed against Mr. Ringler.
Here, you can respond individually or wait till after. I'll wait till afterwards, just to. keep it a little long.
On behalf of Mr. Israel Clary, we are also asking for dismissal of these charges. In addition to the serious concerns with respect to Mr. Giacomo Antonio's credibility, there is a huge problem with the identification of my client as being involved in this matter. Apparently, the testimony was the first indication Mr. Giacomo Antonio had that my client was involved was a cursory 30-second scan of Mr. Ringler's Facebook friends, during which he testified he assumed he would find the other individual who participated in this. So we have an unguided, undirected, unwarned, unsupervised picking of a photo from Facebook out of a group of people and about 30 seconds worth of looking at it. And then he decides this is the guy that had a gun on me. Then we have a photo lineup in which his suspicions apparently are just there to be confirmed by law enforcement, who presented Mr. Giacomo Antonio with one of the worst photo lineups I've ever seen in terms of taking a description of an individual who's been provided, which was a very brief description, cursory description of a black male with black hair, maybe skinny or 120 pounds and short. And then law enforcement provided 5 photos of various races, maybe Caucasian, maybe Hispanic, maybe Middle Eastern, real hard to say, and only one individual who has, I'm not an expert, but I'd say any characteristics one might describe as belonging to an African-American male, and that was Mr. Clary. So of course, Mr. Giacomo Antonio picked Mr. Clary. Not only has he already decided based on a review of a Facebook photo that this is the guy, but he's got no real choice. None of those other 5 even remotely meet the description that Mr. Giacomo Antonio gave to law enforcement the night of the alleged robbery, or 2 days or 3 days later when he gave the written statement, which I think the court also has in evidence. The other problem we have is the testimony here, uncontroverted, is that Mr. Giacomo Antonio received absolutely no admonitions or warnings with respect to that photo lineup. Now, we know that typically law enforcement is supposed to, or at least should be ideally, giving some kind of warning to an individual. Hey, we've got 6 possible photos here. The person who we suspect or you suspect may or may not be listed in this. It's just as important to exonerate the innocent as it is to find the guilty. But Mr. Giacomo Antonio said, nope, they just plunked down this very, very suggestive lineup and said, do you recognize anybody? So all of those things then lead us up to an in-court identification of an individual with a mask. There's no testimony that Mr. Giacomo Antonio has ever seen Mr. Clary with a mask, but of course, because he's here and he meets his expectations of who he was expecting to have here, the young black male involved in this, he picked my client as the one supposedly with the firearm in this case. A few things and the reason that I introduced the booking shots. Mr. Giacomo testified that the individual that had the gun, the shorter, skinny black male, had short hair and a short beard. And this was clarified. He gave those statements to my investigator more recently, but I believe that that was his testimony. Just a few short days after this alleged incident, we have Mr. Clary being booked in with not short hair and not a short little goatee or neatly trimmed beard that Mr. Giacomo testified the individual with the gun had on January 30th. Now, we all know that one can go down from long hair and a long beard to short within a matter of days. We can't go the other way. It's biologically, that doesn't work out. So Mr. Clary's appearance just a few days after this alleged incident indicates that he is not the individual who had that gun. I think arguably the strongest piece of evidence, and I know the court said it was sort of disregarding the comment about the person with the gun having a cartoon face. But I actually asked Mr. Giacomo what he meant by that. He described that he meant the person had sort of a smushed or flattened face. And I don't have the exact quote, but I believe that's what he said. And the reason that I wanted the court to see both the booking photo of Mr. Clary as well as just see his face in court, that does not remotely describe Mr. Clary's face. This is a very particular facial characteristic, someone with a flattened or smushed face. There are obviously other descriptions given by other people we can't get into that weren't part of the evidence, but in any event, that simply does not describe Mr. Clary. He does not have those facial features at all. And those, I specifically asked Mr. Giacomo if there was anything distinctive that he noticed about this individual, and that was his response. But that particular distinctive feature of a flattened or smushed face, again, throw out the cartoon comment, simply does not describe Mr. Clary. So whether we believe that Mr. Giacomo was the victim of an armed robbery or not, Mr. Clary, there's insufficient evidence to indicate that Mr. Clary participated in that he was the individual who had that gun, for all of the reasons I just stated. And with respect, again, to the credibility of Mr. Giacomo, the court saw him, the court had the best view of him. He was evasive. He didn't even want to answer questions at times. He was very inconsistent between statements that he made to law enforcement, and he wanted to write that off as nerves. Well, okay, we can give him that, but then multiple days later, he sits down to have a calm, collected conversation with an officer and writes a written statement in which he makes further statements. We go from having a black handgun that, and he testified he never said it was 9mm. Well, we saw Officer Abrams' video in which it wasn't his wife that said 9mm, it was him. This guy who he testified, he's grown up with guns all his life. He knows his gun. I mean, and he says, initially, black 9mm handgun. 2 days later, reiterates, black handgun. Now, months later, we want to come to court, and I would submit to the court that it is not believable that his testimony, when he said, what did you see when the gun was pointed at you? His response, the make and model. Now, all of a sudden, he knows exactly what type of gun it is. It's a 380 Cobra. And, oh, by the way, yeah, it's silver and chrome. This comes out of nowhere. And is completely inconsistent with all of his prior statements. He was not forthcoming when it came to whether he had contact with Mr. Ringler after the fact. At first it was no, then it was, well, I got a number. He denied ever having told law enforcement that he had contact with Mr. Ringler after the fact. But again, it's evasiveness, it's inconsistency. Given all of that, Your Honor, we're asking the court to simply to discredit the testimony of Mr. Giacomo Antonio in this case. And again, even if believed, Mr. Clary has clearly been misidentified in this case. Thank you very much.
Thank you. Credibility seems to be everything that this preliminary exam seems to be resting. So starting with the defense counsel, defendant one credibility issue regarding the picking up and the dropping off. Your Honor, this is a case in regards to charges of armed robbery. As the officer today stated, And let me clarify that in no way do I believe that officer at any time was lying, but she was forthcoming and that her report was a summary of all the information she obtained that day. She also admitted that it is possible that the complaining witness could have said things differently. She herself has no idea where supposedly they were picked up, if they were ever picked up at all, or if that was ever actually said, because it is not a statement or quote from the complaining witness. And as far as this credibility, nonetheless, this officer at no time goes against the credibility of the complaining witness to indicate what is important in this case, the fact that there was an identification of both defendant 1 and 2. Regardless of how we like how defendant 2 was described, there was an identification. The fact that he was a black young male, that he was from 100 to 120 pounds, that never changed, not from the video, not from the officer's testimony, and not from the complaining witness's testimony. Again, we may not like that he calls, however he describes it, I understand that, but again, when it comes to defendant 1, we even see it in the video that he's actually showing the officer a picture of Justin Ray. Now, I'll come back to credibility as it pertains to defendant 2, Israel Clary. But to go on with the testimony as far as defendant 1, at no time has at all, not even the defense's witness, at any time indicated that they misidentified the defendant, Justin Ringler, defendant number 1. The complaining witness testified that he knew him. He showed a picture to the officers. We see that on the video. Officer confirmed that. And now, as far as the reasoning to go pick up Mr. Ringler and his friend Israel Clary, no testimony came out from the complaining witness about narcotic sales. Defense asked him, and he answered in the negative that no, he was not going there for narcotic sales. And defense did not they had an opportunity to ask the officers, and the officer in no way, shape, or form mentioned narcotics, that a sale of narcotics. I know that from all the police reports in this case, there is no charges or even an investigation pending narcotic sales stemming from this particular case. And we don't, and defense did not bring that up. So I find it irrelevant to even to bring that up, because again, nothing was brought in this preliminary exam that indicates anything regarding narcotic sales at all. And if anything, the behavior of the complaining witness, I'm going to be straightforward, Your Honor, he's all over the place. I'm not disagreeing. He is definitely someone who needs to be on Adderall. And we saw that while he was testifying, as he started doing this and fidgeting, and completely understandable that there may be different things that he says at different times, and he's all over the place. But one thing he is never veered from is the identification of both defendant 1, Justin Ringler, and defendant 2, Israel Clary. And at no time did he ever stop and say that a gun was not pointed at him. He's always held true that a gun was pointed at both him and his fiance, and that the gun was held by defendant number 2, and that he said to him to give him everything. So now, was this an attempted robbery or a full robbery? In the end, even the police officer indicates that the Adderall was taken. Now, when this complaining witness, who is all over the place, indicated it, that's a question of fact, but it wasn't her report, and he also testified to it. So at this point, we believe that probable cause has been met with both count 1 and count 2. Regardless of how much we can argue credibility, the complaining witness at no time during his testimony, his reading of his actual statement that he signed, or even with the officer coming forward, did he ever change the fact of where him and his fiance were robbed, the location, who did it, and how it was done? That never changed. So we believe probable cause has been met with that. Now, if they want to argue all of these other little indications as did he get picked up a couple houses down, dropped off, this is a question of fact for a trier of fact. This does not negate the fact that probable cause has been met. An armed robbery occurred. Even the police officer confirms that that is what her report was about, an armed robbery. And the complaining witness testified to that, and he identified both defendants in the case. Now, as far as the identification of, and let me just finish up with defendant number 1 here. Indeed, I don't disagree with defense. Mr. Ringler in no time had the weapon. There was never any testimony that he ever had the weapon. But according to Michigan law, he is an accomplice and an accessory to what his friend did. There was no testimony that at any time he told his friend to stop, at any time he said, I want no part of this, nothing of that. On the contrary, the testimony, based on the testimony, shows for all probable cause, again, this is not a trial, but for probable cause purposes, he did not stop him. He was aware, and whether it was planned beforehand or in the moment he became aware of it, he then was an accomplice and continued with the defendant number 2, and they both ran together, leaving the area with the items that were taken from the complaining witness and his fiance. As far as now going to the identification of Israel Clary, I respectfully disagree with defense counsel as far as the credibility issue. I believe that this is, again, he's all over the place in the way he describes things, saying things like cartoon character and whatnot. It's a little ridiculous. However, that being said, at no time did he change who it was. 3 times he was given an opportunity to identify the person who put the gun to him. And who the person was, same person on Facebook that he found, and he on his testimony indicated that the name was Israel Clary on that Facebook picture that he found. Afterwards, he did a lineup. The same person was picked out, Israel Clary, defendant number 2. And then again, here in court, he pointed out defendant number 2, Israel Clary. And in all of these instances, Israel Clary looks different, but yet the complaining witness knew it was him who put a gun to him and his fiance's heads and robbed them that evening. That is something most people, even people on Adderall and who are jumping all over the place, don't forget. And he never once changed who it was. And he, again, went into a little bit more detail, 120 pounds. I do want to clarify, though, that the complaining witness did not say he had short hair. He said it looked short because he was wearing a hoodie. I noted that in the testimony. He indicated that the gentleman was wearing a hoodie and it looked like it was short. Of course, if I put my, put a hoodie on him right now, his hair is gonna look shorter than it is. And as far as his testimony about his facial hair, what he actually said, he didn't say of it, he said that he had I don't want to quote his roughly or however he described it, but he said short facial hair, which the defendant does have facial hair. He did not indicate whether it was a mustache, a goatee, a beard, or whatnot. He did indicate that. So again, 3 different occasions where defendant number 2 looked 3 different ways, okay? Each time he picked the right guy. Nowhere was it ever stated that he picked the wrong guy or that he wasn't sure. They had the officer up there. We had him on video describing him again. So I do not believe the credibility is the issue there. So I believe the most important parts of this probable cause standard identification has been met with both the defendant 1 and defendant 2. The location never came into question, so that was met. And what occurred, that a gun was pointed at him and they were robbed. Him and his fiance. Now, the little nuances and the details and whatnot, people feel that is, again, can be argued at trial for question of fact, but the credibility for what occurred here should not be in question. Again, people don't disagree that the plain witness is all over the board, but it just, again, strengthens the fact that this gentleman needs to be on Adderall. But the important factors here were met, that both Justin Ringler and Israel Clary together were involved in an armed robbery where Israel Clary held a gun to both Austin Jeff Antonio and his fiancee Jordan Cervantes. Therefore, the people would respectfully ask that this case be viewed in a probable cause standard and be bound over to circuit court. Thank you, Your Honor.
I'll do my best not to torture everyone with the facts again. Wish I could hear this at third circuit, but I'm in the probable cause standard here. I do believe something went wrong in that car, and I'm not ruling out that the complaining witness was possibly selling pills or something else was going on. It doesn't make sense to me that his friend, Justin Ringler, would rob him for picking him up. Something is not right about this case. For Mr. Ringler, the issue, or I should say for Mr. Cripp and his client, the issue is credibility. And as Attorney Cripp stated, now I'll read it to the record, People v. Anderson. We hold that a magistrate's duty at a preliminary examination is to consider all the evidence presented, including the credibility of witnesses' testimony, and to determine on that basis whether there is probable cause to believe that the defendant committed a crime. Whether the evidence presented is sufficient to cause a person of ordinary prudence and caution to conscientiously entertain a reasonable belief of the accused's guilt. There are some contradicting facts here. With the complaining witness, Mr. Jeff Antonio, we call him Mr. Austin. One, he stated that he picked the defendant Ringler up at the gas station versus Officer Abrams testifying that she was told that confusing whether or not Mr. Andrew picked up the defendant, then brought them to the gas station. It was a very confusing testimony, but it was definitely not the same story. Two, Mr. Andrew stated that, I'm sorry, Austin, not Andrew. Mr. Austin stated that when he was on the stand that he saw a silver chrome firearm and that he knows guns very well since the age of 6. And in the statement provided by Officer Abrams, he said that it was a black gun, and also said in the video that it was a black gun. 3, his testimony in court today, or the other day we began this hearing, he stated that one of the defendants took the meds, his Adderall medicine, and in Abrams' statement, Officer Abrams said someone must have taken this medication. Officer Abrams testified today, and there was it was questionable whether or not she took an accurate statement from Mr. Austin. We saw a video that didn't necessarily match up with what she had in her statement. But then she also stated that there was more that Mr. Andrew said, I keep calling him Andrew, Mr. Austin said there wasn't in the statement. So, you know, if I was at the circuit court level, I could do more. This to me is going to be a serious question of fact for the trier of fact. And people beat Anderson also state that accordingly, in considering the credibility of witnesses, a magistrate may only decline to bind over a defendant if a witness's lack of credibility, when considered together with the other evidence presented during the examination, will conclude a person of ordinary prudence and caution from consciously entertaining a reasonable belief that he was guilty. I do believe that there's probable cause that there was a robbery that took place, and that Mr. Ringler and Mr. Clary were involved. And before I get to each element, defendant number 2, Mr. Clary, as Attorney Cohen brought up, the issue is of identification, not necessarily credibility. Is that correct, Attorney Cohen?
Well, it's,
Both.
I mean, it's both,
Okay.
essentially, the credibility is certainly a huge issue, but even if you assume he's credible with respect to his identification, that simply his description is not Mr. Blair.
Okay. And I discussed credibility already. And Mr. Austin was a little jittery. At one point, looking over at me for help while he was testifying and asking if he felt like he was attacked, what can he do about it? And I told him to just calm down and finish testifying. He seemed very nervous. I don't know what that was. His description about cartoon character, as we discussed, it made no sense. He described Mr. Clary as being skinny, about 5'5", 5'6". He said 100 pounds, and he said $120 wet, soaking wet, black hair. It looked short, and had short facial hair. The main fact here, the reason why, and I'm going to bind over on those 2 counts from Mr. Clary, 4 counts, because Mr. Austin did his initial own identification of Mr. Clary through Facebook. And following that, as Attorney Cohen stated, the lineup he's stating suggested, I think a way hearing will be the next step. There are 6 individuals on this lineup, Mr. Clary is on here, however, it's been entered in evidence, so I can speak on it. There are 5 other individuals who I don't believe are the same race. So I anticipate a way hearing coming after that. And I do think the police department needs to do some training on writing police reports, because it caused us to have a way longer exam than we need to because of inconsistencies in what was heard and what was said off of camera and what was written down. So for all of the 4 counts, I am going to bind the defendants over. I do believe that Mr. Ringler, who did not have a possession gun, did assist with Mr. Clary in robbing Mr. Austin and his fiancee, Ms. Cervantes, as he reached across the seat and reached for ADHD meds, which will be a question of fact, because there's 2 different stories. And then also stated, or Mr. Austin stated that the defendant once said, go, 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 after the item was taken. And at that time when that was happening, defendant number 2, Mr. Clary, was holding down back and forth between complaining witness 1 and 2. So for counts 1 and 2, they will both be bound over. And then for 3 and 4, obviously possession of the gun, pointing the gun at both complaining witness's head and saying, give me everything you got, if your wallet would, satisfy counts 3 and 4. So, before I bind over on those 4 counts, does anyone want to address Bob?
I do, Your Honor.
Go ahead.
So currently, Mr. Ringler is under a 5,010% bond with the house arrest tether. And while on his face, it doesn't seem like a lot of money, but to Mr. Ringler, it's unattainable. He doesn't have the money to post. If he were released on bond, he would live with his aunt at Lisa Smith at 2095 Euclid in the city of Lincoln Park. I called her to confirm that.
What city did you say?
Lincoln Park, Your Honor. Before he was arrested, he did have work at Little Caesars Arena doing maintenance. So he had that job, but hopefully he'll get released from custody. So, Your Honor, I respect the court in terms of the bind over, but you can see there's some very strong issues to be raised that would clearly arise to a level of reasonable doubt later at trial. So in light of my client's circumstances, we're asking for a personal bond with the house arrest tether.
I didn't have the last part of that.
House arrest tether.
Any response from the people?
Your Honor, people would object just simply based on the fact that it is a reasonable bond. I am concerned that even if the court were to grant this, tether still costs money. If he cannot even post the minimal bond now, I don't know how a tether would make a difference at this time. If the court is so inclined to grant this, we would indicate that it be a pure house arrest, Your Honor. And that nothing has been indicated about jobs or anything of that nature. And even so, the people would argue against it. So this time, if people object to any change, we feel that it is reasonable, but if, again, if ought to move forward, we would just request that it be a tether and it be a full house arrest without privileges of going to other locations unless there's like some kind of medical emergency or something of that nature.
I know you had a request specific as to Mr. Clary wanted church as well as the other 2 work.
Yes, Your Honor, the court had previously authorized Mr. Clary to be able to go to work provided he could give sufficient documentation to the tether unit. And he has been able to utilize that to a certain extent in terms of going out to work. Unfortunately, his employment is quite far from his home. He does not have adequate transportation. Really the only request I'm making is if the court would allow for him to be able to attend in-person interviews if he can provide documentation or some kind of verification to the tether unit. He's just trying to find work closer to home so that he doesn't have to go so far afield and spend money to get to the employer. But I certainly understand the severity and seriousness of the charges, notwithstanding Mr. Clary's lack of record. So I certainly don't want to. It's not my intention to upset the court in terms of arguing for a more restrictive environment. So I'm trying to be mindful of that. That would be the only request.
Okay, Ms. Barrett?
Your Honor, it's as if defense could read my mind. I am definitely arguing for more restrictive bond requirements for defendant number 2. I was not so, I know I said I deferred on defendant number 1 based on the testimony that was given. These are, yes, very serious charges. The defendant is being accused of holding a gun, regardless of the reasons of why they met up or anything of that nature, whether they were being driven. There's no testimony that was given that would indicate that on a probable cause standard that this didn't happen. He is accused of putting a gun to 2 people's heads. All it would take is a little flick of the finger on accident, and now he's killed 2 people. So, and as far as church, he should have went to church that day instead of
supposedly doing this crime. So the people would object to not only church, but we would also say, as far as work and interviews, that should all be put on pause till he can prove he's innocent on these charges. The people would ask that the bond be increased. Normally, I would say that I would like to see him have a much higher cash bond because of the testimony that was provided today. But I would appreciate if we could restrict him to being on full house arrest and not having privileges of going to work. They just indicated that he doesn't have good transportation and able to go to this job that is far away. So I don't believe I'm arguing a loss of employment because it seems like he was already about to lose his job, hence why he's looking for another job. So he can look for another job online from home, but I do not believe that the seriousness of these charges, that this person should be allowed to go out and about. He should, at the minimum, be restricted to full house arrest and no contact whatsoever, not even from a third party or any other measure, because it's come to like these people may all know each other in some way or another, Your Honor. And that no contact should be made by either defendant 1 or defendant 2 with anybody involved in this case, both complainant 1 and 2. But that would be our request for defendant number 2, that his bond be increased and he be restricted at a minimum, if not a cash bond, at a minimum, be restricted to house arrest with no options again, unless it is for emergency, a medical emergency or something of that nature. Thank you, Your Honor.
Has anything happened since the last time we addressed about Mr. Clary for bond to be increased, other than the accident? No. Nothing has happened since the last time we were here regarding Mr. Clary.
I mean, aside from the testimony that's come out, Your Honor, and again, like I said, that there was no testimony that would have indicated that, that there's a defense to him holding a gun to people's heads. All the testimony was on other matters, nothing ever about him not actually doing that.
Mr. Clary, are you still at 365?
Yes, ma'am.
Okay, so let's start with Mr. Ringler. I am going to adjust your bond as it is excessive in your situation. I believe whoever sent your bond thought it would be reasonable, but apparently you can't post it. I'm going to change it to a personal bond, but it'll be $50,000 personal. So what that means is if you violate any condition, we're going to be right back in the Wayne County Jail and have to post $50,000 cash. And affordability won't be an issue. Okay, you understand that?
Yes.
Okay, so with that, you will be on house arrest at 2095 Euclid. That's your mother's house?
On hand.
Your aunt, is that where you're going to be?
Yep.
You had your hand up for something?
For work, I was gonna go to a temp service, get a job the next day. Right by.
You mean tomorrow? Or when you get out?
Find out.
Okay, I'm getting to that. So you'll be on tether. You can work if you can provide proof of employment as well as the times you will be employed. The tether unit is very specific about that. Attorney Cripps and Attorney Cohen, if you provide to the court, I can always respond quickly to the tether units, so it won't be any delay. No contact with, this is for both of you, no contact with complaining witnesses or each other. I don't know if you all know each other, please do not tell me if you do. If you do all know each other, please, no contact. That's an order, okay? For Mr. Clary, the only thing I will change here, I'm not going to increase your bond. It's already $100,000 personal. I have not received any information that you have violated your conditions. You are on house arrest. I have here that except for therapy or for work with verification, and I will include if you have proof of an interview. Oh, and no visiting the location that this incident happened. I forgot to say that for both individuals. And Mr. Perry, what's the church, the name of the church that you want to go to?
I just in my phone, so I know it.
I can't hear you.
It's in my phone. Like, I don't know about her.
Honor, may I, and I don't mean to interrupt you, but let me. Okay, thank
So
you.
you don't, it's a church that you don't know the name of?
Yeah, I've never been there, but they want me to go there.
Okay. Do they have online service?
I think
Okay,
I can look that up.
we're gonna stay on online
Yeah,
service
I
for
can
now,
look
okay?
that up.
Okay. So the only thing I'm gonna change on yours is just allowing you to go to interviews.
Yeah, because I've had job interviews like past, like yesterday and all that stuff.
You just have to have proof. If you can provide proof with an interview, just ask them to put something in writing. Then you can go, I want you on work. That's what you all should be doing.
The job that I got right now, I can still work there, but it's like, I'm not gonna keep, I gotta pay for the tether and then pay for Uber that I don't want to do.
That's why I want you on work. So you can continue to pay at least your tether and take care of your family. Doing something constructive, that's why you stay. And no contact with each other, who's declared, goes back and forth, no contact with complaining witnesses. And that's it. So with that, I will have you all bound over. It will be 1 week since Mr. Winkler is still in custody. And I don't know, to tell you, it takes up to 7 days sometimes to get a tether right now. So it'll be March 20th at 9:00 a.m. Frank Martin Hall of Justice for an arraignment on the information. Okay, anything else?
Oh, yeah, thank you.
There you go. Thank you very
Thank
much.
you all. We are off the record.